Today we're going to talk about making sense of patents, and this is just a collection of other topics that weren't big enough to form their own session. So it's 5 different areas that we're going to look at today. So here's the overview. We're going to look at patent code words, words that have special meanings in patenting, trade secrets. We're going to talk about patent numbers, and we're going to talk about the fact that if you have a granted patent, it does not guarantee you the right to practice. And finally, a very short section on patent search scopes. I want to remind you that nothing that is said here today should be construed as legal advice, because I do not have standing to give legal advice. So here's a list of code words. Now, these are words that have special meanings in the world of patenting. And the first one is specification. In a patent document, everything that comes before the claims is generally called the specification. So some people exclude the front page, which is called front matter, but if you talk about the specification of a patent, that's talking about all the disclosure, the discussion of the background art, the broad summary, and the examples and all the detailed description, and it's everything that comes before the claim. One of the most important dates in the life of a patent is called the filing date, and that is the date when a patent application is registered in a patent office. Now, this can also be called the priority date if it's the first filing, because sometimes people will file in one patent office, and then they'll file in another patent office, and then they'll go into a third patent office. So for example, the patent we looked at last week, it started in Sweden. It went into the PCT, or the World Patent Office, and from then it went into a national application in the US Patent Office. So you could say there were 3 different filing dates depending on where you filed. The priority date would have been the date of the first filing. You will often find in a claim the use of the word said, and so you can talk about a process for making the said process comprising. And so said means the one I just mentioned. You can't just start with said, you have to actually name the thing first, and then after that, when you're referring back to it, you could say said, or the, or sometimes such. Once again, an element in a patent claim is not gold or cadmium or something like that. It will be a step or a part. And so as we discussed before, when you have a patent claim, you'll start with a preamble, you'll have a transitional phrase, and then you have a list of elements or steps or components or parts, and each of those is a limitation of the preamble. Another thing that's kind of a code word in patents is called the best mode. Now, the best mode is a time-stamped knowledge that is the best mode that you knew for carrying out the patent claims or the patent process at the time of filing. So you start your research and you get better and better and better and better, and then you find something and you maybe have some experiments that aren't as productive, but when you file the patent application, you can say, this is the best mode. And you keep that information to yourself, but you make sure that that's in the claims, because it has to be in the claims. What happens if you file the patent claim and you continue to do your research, and 2 months later you find a new best mode? Do you have to go back and change it? No, you can't go back and change it. If you want to capture that new best mode, you have to file a continuation in part, which would contain all of the old information plus the new information. But if you're lucky, and if your patent agent or patent attorney has been really careful and crafty, they will have crafted your claims in such a way that your best mode, your new best mode, is actually contained within the claims. It doesn't happen very often, but in this case, you will have a claim that covers your best mode that is not known, it's not disclosed in your application, but you still filed your best mode at the time, so you've actually still kept your responsibility or kept your obligation to the patent office. Finally, we have Embodiment and state of the art. An embodiment is something like an example. And so we talked about this where the detailed description will talk about an embodiment. In an embodiment, A and B are combined in the presence of C and heated to 140 degrees for 2 hours. That would be a way of carrying out, a complete example of how to carry out the process that you're patenting or to make the composition that you're making. They're also called other things such as aspect and preferred embodiment. And you would think that a preferred embodiment would be preferred over an embodiment, but it's not. It means it's preferred over an embodiment that's not named here. And then state of the art, that's probably pretty easy to understand. That would be a complete picture of the related art that would impinge upon whether or not you can get a patent claim. Now we have these two words, and these two words are very special words that don't mean what we would think they would mean usually. Novelty is something that we all kind of have an idea in our mind what it means, as would be obviousness. But in the patent offices, these two words have very special meanings, and actually they are defined by statutes, US 102 and 103. And so the definition of novelty means it's not been patented, it's not been described in print, it's not in public use, it's not on sale, it's not known anywhere basically. But another aspect of novelty is that it can't, something could be novelty destroying if it was in somebody else's patent application that they filed 6 months ago. So here's the first filing. 6 months later, there's a second filing. That's your filing. But of course, you can't know what's in the first filing. You won't know until 18 months later. And so when that finally publishes 18 months after filing, it could be novelty destroying for you. But at the time that you filed your patent application, it was not known. So you can't just be everything that's known. You really don't know until your application publishes if there wasn't something else that would destroy the novelty. And then obviousness is an imaginary person, the person having ordinary skill in the art, is invoked by the patent examiner to say, no, you can't have a patent. Because the person having ordinary skill in the art would have known about this paper, this patent, this paper, and they would have known about them, and they would have had the idea to combine them to get what you have claimed here. They usually invoke this argument when they can't give you a novelty or a 102 rejection, and the obviousness rejection, the 103 rejection, is the most common rejection that a patent office will use against a patent application. Finally, this is a word that's very loaded, and I very much caution people against ever using it, and that would be prior art. Now, the definition of prior art is everything that you would find printed anywhere. Maybe the favorite example is an obscure thesis in a language that you don't know on a bookshelf of a library in a town that you'll never visit. But if it's still printed in that thesis and publicly available, it could be considered prior art. However, the reason I caution people against referring to prior art is because if you call something prior art, like let's say you write an argument for the patent attorney who's defending your case, and the patent attorney is sloppy and doesn't review it and find the words prior art in there, you're calling something prior art by mistake could be used against you by the patent office. So any admission that a patent applicant makes to say that, well, this paper is prior art against my claims is a way for you to lose your application, to lose the grant of your patent. Let's talk about trade secrets, okay? Now, there are some requirements for a trade secret. For a trade secret to be considered a trade secret, it has to fulfill these three categories. It has to be secret information, it has to give you a business advantage, and it has to be the object of efforts to keep it secret. It could be any kind of knowledge that gives you an advantage and is kept secret. So for example, let's say I got a job at a cheese factory, and I walk into the cheese factory, and I am being shown around, and I'm going to make cheddar cheese in this vat. And I've made cheddar cheese before, I know how this is done, but then I see this piece of equipment and it's all plumbed in, and it's a smaller tank. And so I asked the boss, what's this? I said, well, that's our ingredient X tank. And so here's how you make ingredient X. And then at this certain time point in the fermentation, you will inoculate the vat with this stuff. Oh, okay. Now, they just told me something, but in this case, they didn't tell me it was a trade secret. So it's not the subject of efforts to keep it secret. Now, if they did it right, they would say, okay, now this is a secret. And they would actually have me sign a piece of paper to say, I'm given secret information and I will keep it secret. And then I sign that so that in case I ever did divulge it, I'd be liable. So trade secrets are protected statutorily in the US Patent Code now. And in the past, if you had a trade secret and somebody filed a patent application that and disclosed your trade secret and got claims, you were just out of luck. But now there's a provision whereby you can continue to operate your trade secret, but you can't expand to a second location and you cannot expand the scope of your operation. It's all very secret and hush-hush though. So these are some of the questions that people need to ask themselves about whether or not they're going to have a patent application or they're going to try to have a trade secret, because there are advantages to each of them. First of all, if you can't keep it a secret, then maybe you're better off filing a patent application. Second of all, a lot of times there's no way to tell if somebody would be violating your patent. There could be no way to detect infringement, and therefore the patent claims would be unenforceable. Well, then you might think it's probably a better idea to have a trade secret. Now, if you are developing a technology in a field that is very knowledge dense, very complicated, there are many, many patents out there, and the field is rapidly advancing, this could work either way. If it's very knowledge dense, you could have a very difficult time convincing an examiner that a patent claim is novel, because there's so much other information out there, and the patent examiner will just keep rejecting it over different information until one of you gives up. If the field is acknowledging, or if the field is advancing very quickly, sometimes that's an opportunity to file a patent application. Sometimes it's best to keep it a secret, because there could be a lot of applications that were filed in the 18 months before you that would have your claims already in them. And the last question is, would patenting reveal any of our trade secrets? Now, this is kind of a question of not being sloppy. However, at one time I was called up by a business person in the company I worked for, and they said, hey, have you seen this patent application? And I said, no. And so they sent me the number, and I looked it up, and they said, look on page 21. And I looked on page 21, and they said, these people who are our customers and with whom we have worked on several projects over the years have disclosed our secret process in their patent application in an example. Sure enough, it was there. So in this case, it wasn't us disclosing something, but it was somebody else that had our secret knowledge telling the world. And it was a very difficult decision how to handle that, because they were customers. So here's a little break slide, a secret code for keeping a trade secret. They turned all their ones and zeros upside down, so nobody will ever be able to figure out what their code is. Okay, let's talk about patent numbers. Now, this is something that really bothers me, so I might get a little bit heated here. So, if you ever you're reading a paper and they're referring to something and they say so-and-so's patented technology, and then you look in the back and you see US number 2011123456A1. Well, they have referred to a patent application. That's not a patent. So it's not patented technology, unless it is, but that number doesn't tell you that it's patented. So then people will be like, well, I'm not going to do any research there because it's patented and I don't want to get in trouble. What people don't realize is that the specification and claims of a patent application and the specification of a granted patent can say anything. There's no reviewer that says, no, you can't say that. There's no editor reviewing process like we have with papers. You can put anything you want in a patent application. And so if somebody thinks that this application is a patent because they don't know about how to read patent numbers, then they could warrant that it's patented technology, but it's not. So I have a couple examples here. This first one here, okay? Now we see right away it's an application. It starts with a 2006 and it ends with an A1, so we know the A is a patent application number. So it looks like a pretty good set of claims. One, a training method, the preamble, comprising, that's the transition phrase, the steps of. Okay, now we're going to have our elements, our limitations. Generating a banner, having a plurality of footsteps, spaced at regular intervals, wherein the banner is placed on the ground. Okay, that sounds very straightforward. Okay, you've got footprints and they're evenly spaced and you put them on the ground. Second limitation, generating a periodic audible signal whereby the audible signal repeats at a regular interval of time equal to the period. So basically, it's just a nice, even, repetitive signal. Could be a bell, could be a clap, whatever. Third limitation, or third element, walking on the banner by tracing the footsteps spaced at regular intervals when one step is made with each audible signal. This is a really good claim. It's very clear, it's unequivocal, and it's quite correct. So this patent was never granted, and I'll show you why. It's a training system to allow people to walk through doors and walk through walls. Okay, so if you didn't know this, that an A1 was just an application, you might say, wow, somebody patented walking through walls. What is the patent office thinking? The story is there was I believe it was a Jesuit priest who was known for praying for people who were sick. And this person was also known for walking at a very dignified pace with always taking the same size steps, and they would walk from one place, from one city to another, and they would go into hospital rooms and they would visit the sick people. And on one occasion, the legend goes, they were observed coming out of the hospital room, but they were never observed going in. And so the legend sprang up that this person could walk through walls because of their way of walking. And so somebody, having heard the legend, decided to file a patent application on it. The patent was never granted, and I always thought that was a shame because all they would have to do would be to travel to the patent office and have an interview and walk through a few doors. But apparently they didn't. Here's another one. This again is a patent application. Now this is a story from the class that I monitored to become a patent agent. And so the person who was teaching this class had been a patent examiner, and they had a claim similar to this. So I have taken their story and written this claim. So we have a method of making a brick. It's our preamble, comprising our transition phrase, and then we have our elements. Supplying a brick mold, element 1, supplying mud, element 2, supplying straw, element 3, mixing said mud, that mud, with said straw, that straw, in said brick mold, that brick mold, to obtain a uniform dispersion of straw and mud, and drying said dispersion to obtain a brick. That's a pretty good claim. And here we have people actually practicing the technology. Looks pretty good to me. Well, this person said that they had to reject this claim based on technology from Egypt from 1300 BC. It's in the Bible. And so you could write a claim like this and you could put it out there and somebody say, wow, people are inventing this really cool modern technology. But that doesn't mean that it's any good just because it's in an application. So let's talk about facts about patent numbers now that I hopefully have warned you. You can only call it patented if it's in a claim in a granted patent. Okay? If it's in the granted patent, in the specification, but not in the claims, then you can't call it patented. And if it's in the patent application, you can only call it patented if you look in the corresponding granted patent and find that fact in the granted patent. Otherwise, it's not patented technology. Sometimes we see that people refer to patented processes and compositions, but I'm here to tell you, most of the time I see that reference, it's incorrect because people just don't understand. Well, we're going to fix that right now. These three facts are all you need to know for today, except for when you don't. So first of all, you will almost always find a patent application having a suffix A1. Could be A2, could be A4, could be A8. The numbers mean something different, but it's nothing really that I want to go into right now. If it's a granted patent, it will usually have the suffix B1. So for example, if you look at a European patent application, it will be a long number and it'll end in A1. If you look at the corresponding granted patent, it'll be the same number, except it will end in B1. Now in the US, you'll have a number for the patent application ending in A1, but you'll have a different number for the granted patent ending in B1 or something, usually. Now, the US was late to the party in this whole thing about publishing patent applications, and so anything that's before the year 2000, you won't see an A or a B at the end of a US patent number. Only patents were granted. There were no such things as granted US patent applications before about the middle of 2000. So those are some of your keys. And then you should understand that nothing that comes out of the PCT, nothing that has a WO at the front is a patent. It's only an application because the World Patent, the World Patent System or the Patent Cooperation Treaty is a way whereby you can file one application in one office and have the same filing date all over the world. Because if you couldn't do that and you had to mail your applications to 6 different offices around the world, they'd get there at different days, they'd be entered on different days, and then this one over here in Malaysia could be prior art against this one over here in the Netherlands. And then you can't get your patent over here because this one was filed one day before. That wasn't perceived as fair. So let's have a little quiz. Does any of this make sense? Here's one. Alistair McRae, the father of modern lipase interacerification. And he had a patent application or a patent or both, let's look here, on interacerification of oils and fats. And we see here that in Australia, we see that that's the one with the AU, 1977, that's the year, and it ends in an A1. That's an application. In the US, it's before the year 2000, so it has to be an issued patent. That was easy. No B, but it's a granted patent. Here's one from Bungie. Bungie is a platinum corporate member of AOCS and a very strong supporter of AOCS. And this patent application for interacerified hydrolake vegetable oils is, look at W0, A1. It's an application. Besides, I said it was an application. Here's one from Novozymes. Novozymes is also a platinum corporate member, and they've got this one for these little tiny particles of enzyme that they use. You know, the Novozymes enzymes have enabled the development of the trans-free industry in the world, because they have made this enzyme a great success technologically. They're immobilized lipase, and it's cost effective because of their support. And here they have made an improvement on the support. Their enzyme particles are even smaller. And we see here again, WO, it's a patent application, ends in an A1. And finally, here's one from ADM, another platinum corporate member. Renewable source-derived polymer oil macroinitiators and thermoplastic block copolymers derived therefrom. I wrote this patent, and I'm happy to say that it published as a application, and it also has been granted. And you see the bottom number there, US, 8 digits, ending in B2. It's a really cool technology. The guy who invented it really had a great idea. So these are my suggestions when you are going to refer to patent applications or patent numbers, okay? If you're going to refer to a patent application, I recommend that you write it something like this. A patent on this technology is granted in, and put the year. The reason I say you should do it that way is because when you get a patent, you have to file the patent, you get the granted patent, and then you have to pay money at 3.5, 7.5, and 11.5 years to keep the patent alive. And you don't know unless you know how to find out from looking in the patent pair or Mindsoft's tool that they're going to talk about tomorrow, the patent base, will also pull that information in. You don't know if it's actually, if those annuities have been paid. So after 5 years, it may no longer be a patent. So you wouldn't want to call it a patented technology unless you're being ambiguous and meant that, well, it was the subject of a patent application, and that there's no reason to say that because you might mislead somebody into thinking that the patent's still in force. So a patent on this technology is granted in such and such a year, and then when you're going to refer to an application, I would say you should just talk about it was the subject of an application or was published on such and such a year. Don't talk about when it was filed, just talk about when it was published. Those are my recommendations. Excuse me. This is an interesting topic that is not always understood. So we're going to have to go and have a little, oh, here's some background information. So there are 3 different types of patents that we refer to: utility patents, plant patents, which are actually plants, like, you know, the green growing things, and design patents, which would be the ornamental design of a candle holder, okay? And you can get a patent granted on that. But most of the patents that we deal with in science are called utility patents, and they're normally good for about 17 years from the date of issue, which is also the date of grant. There's such a thing as patent term adjustment, and if you've wasted time in the patent office, you don't get that time back. But if they wasted time, they get the time back. So, for example, one of the patents that I got allowed was actually a really good technology, a very strong technology, and I had to fight for 6 years to get the patent granted. But the fight was very much intermittent because the examiner kept getting pregnant and going on maternity leave. So I would correspond, and all of a sudden there'd be no answer, and then a year later I'd get an answer back. And then I actually had to take 2 trips to the patent office to talk to the examiner to explain what was going on. Apparently my writing was bad enough that I couldn't make sense of it. And in the final interview, I remember I brought the actual material that we had in our claims, and I brought the material in another jar that contained the material that she was rejecting my claim over. And I said, now this is the stuff we have, and this is what you're claiming is the same. Open it up, smell them, look at them, handle them. Are they the same? And she said, well, these aren't the same at all. And I got my claims. So now this is the point, though, that I'm trying to make. Having a patent, a granted patent, does not give you the right to actually practice the patent. It gives you the right to exclude other people. from making, using, selling, offering to sell, or importing the claimed object. So let's look at this little story, okay? So you have to use your imagination. Let's go back in time. There are no chairs in the world, okay? Everybody sits on rocks. Otherwise, it looks much like this, but there are no chairs, only rocks. And so my friend was sitting in his house and the power went out and he was trying to read, and his rock that he was sitting on was not over by the window, and he couldn't move it because it was a giant boulder. And it really bothered him. So he started thinking about it and he said, you know, there's a way I can get around this. And so he invented a stool. And so he took it to his friend who was a patent attorney, and the patent attorney looked at it and said, this is really cool, and drafted a patent application, and this was the first claim. So the claim was a stool for sitting, comprising, so the stool for sitting is the preamble. It could have been called a device for sitting, a platform for sitting, but they called it a stool. Comprising, that was the transitional phrase, and the first element was a platform. So that's better not to use platform in the preamble. And second element, 3 support members maintaining the platform at a distance from the floor. Okay, so they wrote the patent application, they filed the patent application, and the patent examiner picked it up and went, wow, a portable rock. This is really cool. And they granted the patent. And so my friends started their own company. They started making furniture. And they made a bunch of money and bought the dream car. Okay, so I went over to my friend's house and he let me look at his car. Didn't let me drive it though. And then he took me inside and showed me his stool, and this is pretty cool. Well, you can sit on the stool. So I sat in the stool and I'm sitting around thinking, oh, this is pretty interesting. And I got it up, moved it, and oh, this is pretty cool. And then I sat down and I fell off of it. I tipped it over because it only had 3 legs. Well, that was pretty embarrassing. And the second time I spilled my coffee, and so then I was really unhappy. So I went home and I said, there's got to be a better way. And so I invented a stool with 4 legs. Now you have to pretend with me that the patent office would have granted this patent, okay? It's not inconceivable, but it's not likely. And so I filed a patent application, and the patent office granted this patent, and it was almost identical, except it was a stool for sitting comprising a platform and 4 support members, maintaining the platform at a distance from the floor. And so I started selling them, and I bought my dream car. And they were selling theirs, and I was selling mine. And then my friend's patent attorney gave me a call. He said, Scott, well, friendly call. I don't want to have to send you a letter. I don't have to talk to your attorney, but you have to stop making your 4-legged stool because you're infringing my client's patent. And I said, what? They said, you have to stop. I said, I don't have to stop. I have a patent on my stool. The patent office said my stool was a great invention. And the other guy's attorney said, yeah, you know, you're right. You have a granted patent, but you still have to stop because you're infringing my client's patent. I said, that's ridiculous. I'm not infringing. I have a patent. How could I be infringing? And so, you know, we went back and forth like that. And finally, the other attorney was very patient with me and said, okay, let's play a little game. Okay, I'm going to ask a few questions and I want you to give me a simple answer. Okay, it's kind of an easy game. Okay, so Scott, your stool, your 4-legged stool, does it have 1 leg? And I said, yes, my patented 4-legged stool actually has 1 leg. Okay, so then the attorney said, does your patented 4-legged stool then have 2 legs? I said, yes, as a matter of fact, my 4-legged stool has 2 legs. And they said, okay, 1 more question, please, Scott. Does your patented 4-legged stool have 3 legs? I said, yes, it has 3 legs. Obviously, it has 3 legs because it also has 4 legs, and it's patented, by the way. And the attorney said, my client has a patent on a 3-legged stool. And so you cannot make your four-legged stool without infringing my client's three-legged stool patent. So I had to stop. Now the good news was I got to keep my car, and I went to work for my friend, and everything turned out well. But the lesson is, just because there's a patent out there, that doesn't guarantee anything about the right to practice it. Finally, we're going to talk very briefly about patent search scopes. So of course, in the process of doing research, we need to ask questions, we need to find papers and patents, etc. And so there are certain questions that I am going to enumerate here about where to look when you are going to search. Now, it's a little tricky because you never want to be, unless you're a patent attorney, and then you already know this, you never want to be in the position of saying, we have freedom to operate. In fact, it's against the rules to do that because then you're practicing law. So you can give an opinion. You can say, well, I couldn't find anything that would prevent us from patenting this technology, or I couldn't find any patents that would, any patent claims, any active claims that would cover this technology. But a patent attorney has to get, and it can't even be a patent agent, a patent attorney has to give a legal opinion that says, okay, we have freedom to operate here. So these are a few questions here, or a few questions you want to ask and where to look. So if you want to know the state of the art, which is something you need to know when you're embarking on potentially patentable technology, you need to search everything. Everything that's been published, everything you can find. And how do you know when you're kind of getting close to the end? Well, when I would draft these documents that I would then send to attorneys for their review, and they would then decide whether or not they would publish them, I would write, I am 90% sure that I found everything. And you become that sure by asking the questions as many different ways as you can, tracking down different keywords that you learn in the course of your searching, and then finding the same answer over and over and over. When you always find the same documents over and over, you know that you're pretty close to done. What about if you have an idea and you want to know if it's patentable? Well, you've got to search in the same area, everything, because you haven't filed a patent application on it, apparently. So you have to search everything that's been known. Here's another question. Okay, I developed this technology, it's a purification technology, and the company doesn't really like the patent, but I want to find out, I want to make sure that I wouldn't be infringing somebody else's patent. So this would be called freedom to operate, or clearance, or white space, or well, maybe not white space, right to use search and non-infringement search. And so then we have to actually search is any active patent claims, the active patent claims that will define whether or not you are able to actually practice the technology. One of the best things you can ever do is to find a technology that's described in a patent that's expired, because it's expired. Nobody can claim that again. There can't be another brand new claim on exactly that technology because it's already been published and patented and it's expired. And so those are gold mines. Knowing how to read patents, and especially expired patents, and pulling out the information is a very strong skill to have as a researcher. And the last question, is this competitor's patent valid, or is this patent valid? And then what you have to do is you have to know the priority date, the filing date, and you search everything before that time. You're also going to have to look for anything that came within 18 months that would be a patent because of that extra clause we talked about. Generally speaking, that would be considered a subset of the other. And so finally, we're done. And I would be happy to hear if you have any questions.
Thank you, and I love the examples and great stories. If you do have any questions, please do write that in the question panel, and Scott will answer those. While I'm giving everyone a moment to pose their questions, just a reminder that we will have our final patent webinar in this series tomorrow. Registration is free, and that will be with Mindsoft, and they will go through patents and R&D and searching PatBase.
I have seen that webinar, and it's a good one.
I'm looking forward to it as well. I'm currently actually not seeing any questions. Oh, here we go. Got that out. I think I just had a delay, and now they're all coming through. Okay, you mentioned that expired patents are a gold mine. What if a patent is abandoned? Are claims from an abandoned patent also valuable?
Yes. It would be considered, now when you say abandoned, what I'm assuming, what I'm taking that to mean is that a patent was granted, and with the payment of the grant fee, they obtained a 3.5-year term. And then when the renewal came up, they decided not to renew it at 3.5, 7.5, or 11.5 years at some point in there, and it was abandoned, it lapsed. Those claims are then, or the technology in the entire application would then be considered part of the gold mine.
If a patent is expired due to fee-related issues, does that give freedom to practice? Can the inventor come back and pay the fees and make the patent active again? So building kind of on that previous question.
Yeah, there is a grace period, and I believe the grace period in the US is 6 months, but I'm not sure. It's not a question I ever had to deal with. But I do recall when I had to study the law that it was possible, and I believe it was 6 months. And there's a penalty that may be where you have to explain why the abandonment was unavoidable. So it's possible, but not forever.
Okay, thank you. If we cannot do an exhaustive search on patents, how do we make sure that we do not infringe on any? For example, conduct lab experiments.
Well, I'm of the opinion that you can save a half an hour searching by spending 2 weeks in the laboratory. So I am a very strong proponent of making sure that you've done your homework and searched and searched and searched so that you are very knowledgeable about the subject before you start working in the laboratory. Sometimes you're not allowed to do that. Sometimes the boss says, get in there and do something, and then you have to do that. But you can't be sure, even if you've done a lot of searching, you can't be sure that it hasn't been patented somewhere. And sometimes patent claims are drafted in such a way that it's not obvious exactly what they cover. So, for example, I had a set of patent claims granted once for technology, and I got the claims granted because I defined the reactants in terms of their Hildebrand solubility parameters. Now, that's not a very common term that's used to define these molecules, and as a result, the examiner couldn't find any reason to not allow my claims. And so you could do a search on all these different molecule names, but it's possible that you would not have found this particular patent, and therefore you could be operating inside the realm of those claims without knowing it. So you can't be sure, and all you can do is do your best homework and hope it works out.
Thank you. It looks like we have one more question. So should you have additional questions, please write those in. Does the field of the invention limit the scope of the claims? For example, if the claim says food compositions comprising, and the field of the invention states the function of the food composition, does that limit the product stated in the claim to meet a specific function?
It depends. Generally speaking, it is incumbent upon the drafter of the patent claim to make sure that the terms are very clearly defined. And if they're not clearly defined, then you get into a gray area where if it goes to court, a judge will have to have a Markman hearing and have to examine all of the information in the case and decide what the patent terms, what the claim terms mean. And if the judge decides it means A, then it means A. If the judge decides it means B, then it means B. And it's a kind of a convenient fiction that everybody agrees to let the judge do so that we can argue about terms we have agreed on the meaning of. You can answer just about any question in patenting with "it depends."
Very well. Okay, I think that was all of our questions. So thank you so much for doing these 3 webinars with us, and you will be back tomorrow to help moderate our R&D with Mindsoft webinar. But thank you so much, Scott. I think these have been of value to everyone, and there's been such great discussion. So hope to see everyone tomorrow.
Thank you, Amy. Thanks, everybody.
Thank you. Bye, everybody.